Hi there, I'm Savannah Mexto with Manor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney Robert Manor. Today's webinar is especially for our own Michigan Snowbirds. Summer has packed her bags and left, which means fall and winter are right around the corner, and our fair-weathered residents are heading south. Today, Bob will discuss the special planning considerations for those who live in two different states. But before I pass the torch to Bob, I'd like to cover a few housekeeping details. Now, first, even though Bob is an attorney, today's webinar will not give specific legal advice. I encourage you, if you do have a question about your own unique situation, to contact our firm after the webinar. Now, if you do have a general question that comes up during today's presentation, I encourage you to use the question box. We will save time to review questions during the presentation. If for some reason we don't get to your question during the webinar, we will contact you after. Now, lastly, today's presentation will be recorded and the replay will be sent out tomorrow so you can share it with family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Manor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's honored in 2020 as both a super lawyer and a leading lawyer by those peer review lawyer rating organizations. Bob is currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. My own personal favorite reason, Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Manor.
Hi, folks. I just thought this would be an interesting topic here, and we're just going to kind of cover some of the basics of when we have folks that are going back and forth between Michigan and Florida, and sometimes we get the questions about, well, should I be a Michigan resident? Should I be a Florida resident? Is everything I do here going to be okay there? It doesn't have to be Florida, obviously. It could be Arizona, Texas. It could be Iowa, for all that matters. You know, it's just two different states. Obviously, Michigan seems to have that direct connection with Florida, so we kind of assume that when our snowbirds go somewhere, it's often going to be Florida. But obviously, that could be any number of places. So the first question that comes up that I think is really important is, are your Michigan documents going to be still good in another state? And I'm going to kind of dig into this in a couple of different ways. And the first answer is yes, they're going to be good. They're going to be honored. They're going to be valuable in another state. And so from a standpoint, if you're a Michigan resident and you're out of state, do you need to, if you're there a few months, a month, even 6 months, 5 months, whatever, are your Michigan documents going to be sufficient? And the answer is yes. Does that mean it's the best possible answer? Not necessarily. So for the most part, your will, your trust, your financial power of attorney are all going to be fine no matter where you are. If you get them drafted here, you're a Michigan resident. They should be interpreting it according to Michigan law because you're a Michigan resident, even if you're temporarily in another state. The one issue that gets a little bit more dicey is the issue of medical decision making, particularly things like end-of-life decision-making, whether or not to keep you alive on life support and those types of things. So that gets a little bit more messy because every state kind of has their own thing, and this goes to court a lot, and there's been lots of high-profile cases. If you remember in Florida, this goes back a lot of years for those folks that remember the Terri Schiavo matter, right? So there was this woman named Terri Schiavo, young woman in her 50s or so, and she'd been in some kind of diminished state for many years, over a decade, and her husband had said that she was brain dead, and the doctors seemed to say that too, but her parents said no, she was not. She interacted with them. Now she was confined to a hospital, and she was hooked up to for hydration and nutrition and all of that. And a lot of people kind of took sides on that one. It went all the way to Congress and to the president. I think the Pope weighed in on the case. And the thing about it, and what was interesting about it, was a lot of people took sides. The case was actually kind of interesting because there were some messy things. And so one of the things is a lot of people would say, oh, well, the husband who had been married to her for 25 years or whatever it was, obviously he should be the one that makes the decisions. The issue that came up in this particular case was that the husband also was going to get a financial settlement when she died, because there was a lawsuit regarding some of the things related to her illness and whatever resulted in that. But that money was tied up for her as long as she was living. But once she actually died, then he was going to get that money. He also had moved on, had children with another woman. You know, his wife was actually not able to leave the hospital, you know, for the last 12 years, and he felt that there was no brain activity, that she was brain dead. Again, her parents said that's not the case. It was a messy case, and I'm not here to relitigate that case. The thing that I think is interesting about that is we wouldn't know about Terry Schiavo, and we wouldn't have this problem if she had laid out what she wanted. So in Michigan, we use a document that is usually referred to as a healthcare power of attorney. Sometimes we call it a patient advocate. In Florida, they use what often is referred to as a living will or a healthcare directive. So we have different kind of approaches in Michigan and in Florida. And so that's something interesting. And so if you were going to be in Florida for 6 months out of the year, 5 months out of the year, would they honor our healthcare power of attorney, our patient advocate from Michigan? Yes, I think they would honor it, but they'd be more used to seeing that healthcare directive or the living will. So it's something that you might think about if you're there long enough. But I definitely wouldn't redo your financial power of attorney. I definitely wouldn't redo your trust if you're only part-time in a different state. Now, what if you moved? What if you changed your residency? That's going to depend. So the trusts that we draft here are going to be valid in every state. You can put real estate from any state into the Michigan trust. So it's going to be based on Michigan law, but you move to Texas, is that trust still valid even if we put a Texas house into the Michigan trust? And the answer is absolutely it is. If you actually move and you're no longer a resident of Michigan and you no longer have ties to Michigan, should you have it reviewed by a Texas attorney or whatever state it is? Probably. I would, have you give that consideration. Is it absolutely required? No, it's a legally binding document, should work, but there might be some issues with regard to differences in how they handle long-term care or Medicaid or those types of things, which often are going to be relevant as to some of the wording in the trust or the wording in the power of attorney, things like that, as to what's authorized in different states. So just something to think about. But the bottom line is, if you got your documents here, you're still a Michigan resident, the documents you got here should be valid wherever you go. If you have property in Florida, we're going to have the Florida property in Michigan, in the Michigan trust. This is one of those things that we'll come back to in a minute, but the idea is if you do have property in both states, in two different states, it makes it even more important that we do good estate planning, because if you don't, we could end up going through probate in both states, which is what we typically try to avoid, right? Oops, okay, let's see, I'm jumping around here. That was not my intention. Okay, so the next thing here is, what about estate taxes or death taxes? So I've got good news for you as it relates to Michigan if you're a resident of Michigan when you die. And the answer is you're most likely not going to pay any death taxes or estate taxes. So there are no death or estate taxes in Michigan for Michigan residents. There are no death or estate taxes in Florida or Texas. Now, some states do. So if you get to Massachusetts or California or New York, there's a pretty good chance that you're going to pay some estate taxes. Now, we probably have to do some estate tax planning in those states with a lawyer in those states if you move to those states and become a resident of those states. If you're a resident of Michigan and you happen to be vacationing in New York, that's fine. You're a resident of Michigan. Your assets are in Michigan. If you change your residency to New York, then we should probably refer you to somebody that would be able to talk to you about minimizing those death taxes or estate taxes. What about federal government? Does the federal government tax you? Well, the answer is yes, but probably not. And here's why probably not. The current limit is over $12 million. So if you've got over $12 million that you're going to be passing on to your family, definitely stop by our office, because I'm sure that we can find something to do for you. No, of course, we can help folks that have lots of assets, but that's not our average client, right? We don't have a lot of clients that have over $12 million. Certainly we have a few, but that's a rarity. And so for most of the folks that we're going to be dealing with, particularly when you know that if you're married, you can actually double that on the federal. They have what they call portability. And so each spouse can have the $12 million. So we'd have over $24 million that we could pass on without having to pay federal, estate, or death taxes. And they did that years ago. And of course, it could change. You know, the election coming up, anything can change. And we'll keep you informed. Of course, stay tuned to our messages and our webinars. And if there is a change, we'll definitely let you know about it. But right now, if you're a married couple, you can pass on over $24 million without paying a death tax. That doesn't apply to income taxes. So this is where people get confused on this. And so this doesn't matter whether you're in Michigan or Florida or New York or wherever else. And so it doesn't really relate to the snowbird issue. I just want people to think about it. It's true that you're not going to pay any death taxes or estate taxes, but if you have any retirement accounts like IRAs, qualified annuities, 401ks, anything like that, which most of us do, well, for traditional retirement accounts, we have not paid the taxes on those. So traditional IRAs, traditional 401ks, not Roths, we've not paid the taxes on those. And then we do want to do some tax planning on that. But that's not a death tax, that's not an estate tax, that's an income tax. And it's because you didn't pay the taxes on the money when you put it into the account. So that means the money has to be, the taxes have to be paid when we take the money out of the account. And there's things that we can do to minimize that and make sure we're being strategic about that. And that's true whatever state that you're in. The next issue to talk about when we're thinking about from the standpoint of a snowbird where you're spending time in 2 different states is, well, what happens if you get sick? Now, the truth is most of us will get to the point in life where something happens and we're going to need some help. And that's most of us. And nobody likes to think about this. We all would love to be the person that lives to 100. You know, we see these commercials on TV where the person's running on the beach at 100 and they're happy, and somehow everybody in retirement seems to own a vineyard or something. You know, all these commercials for the financial advisors. But the thing is, that's not the reality for most of us. The reality for most of us is there's going to be some period of time before our death where we're going to need help. We're going to be dependent on somebody else, probably paid caregivers, maybe assisted living, maybe home caregivers, maybe family caregivers. But the bottom line is for most of us, probably the vast majority of us, we're going to have some period of time we're going to be dependent on other people for our day-to-day activities, paying our bills, helping us get showered, helping us get up in the morning, helping us get dressed, just general supervision so we don't cause ourselves harm if there's dementia or Alzheimer's or a stroke or something like that. And so one of the things I think it's important to think about is, well, what happens where, you know, and I think you should probably be a little bit strategic about this and think about it from the standpoint of, okay, if I spend half my time in Florida and half my time in Michigan, where is it likely that we would settle if I needed care? In other words, if I need care, if I am going to be in assisted living or I'm needing home care or something like that, means I'm probably at that stage in life not going back and forth anymore, right? We're going to have to stick to one place. If we need that level of care, good chance. I mean, sometimes it happens. I've had clients that needed care and still went back and forth, but that's pretty rare. Most of the time, we're going to pick one or the other. And I think you should think about that and kind of plan accordingly. And so a lot of folks, if your family is in Michigan and you're in Michigan and you say, okay, even if I'm in Florida, if I have a stroke in Florida, I'm going to want to eventually get back to Michigan because that's where my family is, or that's where my church is, or that's my support group, or, you know, whatever it is that you'd want to be back in Michigan. And you're going to want to think about that. But what if the answer is actually no? The reason I go to Arizona 6 months of the year is because that's where all my family is. I want to be there for the weather, but I also have family there. And that in the event that I needed long-term care, I needed assisted living or nursing home or something like that, that I'd probably stay in Arizona. If that's the case, then I have a suggestion. And the suggestion is if we have legal documents, if you're a Michigan resident and we have legal documents, a trust, power of attorney, all those types of things that we drafted in Michigan, I suggest that you let me help you find an attorney that will look over those, because the possibility exists that you'd be in Arizona and you'd be staying in Arizona and we'd be needing medical care, health care, long-term care in another state. And so we're going to want to make sure that the plan that we developed here is also going to be suitable for whatever state that you're in. And I've done this multiple times where I had folks that they said, well, you know, we want you to, Bob, to do the plan. You know, we're Michigan residents, but we imagine that we're probably going to be in Georgia at some point. That was fine. I have friends from all over the country that do the work that I do. I can call one of them up. They're going to charge something, but typically they're pretty reasonable. And I'm fortunate to be able to have you know, colleagues and contacts throughout the country. Call them up and say, hey, let's take a look at this plan. First of all, let me know what you're going to charge to do this, and let me know if there's any alterations we need to do, or whether we're going to be able to follow through on this plan if, God forbid, our client goes into a nursing home and we need to be able to apply for veterans benefits, or apply for Medicaid, or apply for whatever programs that are out there to help pay for care. And so that's fine. It's something that we do. It doesn't mean that we have to, you know, have completely independent lawyers. The lawyers in the two different states can work together. What we've typically done in the past is we prepare the plan, we do everything, but as part of that planning, we get a consult from another attorney in the other state that you may be going to, and just make sure, get the stamp of approval saying, yes, this plan will work also in Georgia. And we've done this multiple times in multiple different states. I know we've done Florida, of course, Georgia, Indiana, Arizona, Texas, where we've had people that were kind of going back and forth, and we just wanted to make sure we were going to have everything work out in whatever state that they happen to be in. Nevada, I know we've had one we did that with. And so, you know, that's real important. Also, if you do end up moving to another state and you need a referral to somebody, again, I've had the privilege and the honor of being able to participate in groups and speak to groups throughout the country. And as part of that, I've met some really talented and smart attorneys that I can put you in touch with. So, other thing that I thought was really interesting here, and that's why I put this graphic on here. Look at this. This comes from Genworth, which is an insurance company. Genworth is an insurance company, but one of the things they sell is long-term care insurance. And so if you look at this, you're going to see that they're saying the average cost of a private room in a nursing home is based on the state. And it goes anywhere from $5,000 per month, that's not per year, per month, up to $28,000 per month. I'm sorry, not per year, per month. And the most expensive, oddly enough, this just seems really bizarre to me, but the most expensive is Alaska. That's the most expensive nursing homes are in Alaska. Not sure why that is, but I've known that. I've seen this statistic multiple times, and it's really interesting. Now, when you look at some of the states that you know, our snowbirds commonly go through, it's actually convenient on our chart that Florida and Michigan are on the same line. You'll see that they're pretty close. This was for 2018, so the price has probably gone up a little bit, but 2018, Florida had the average cost of a monthly nursing home private room as $9,064 a month, where Michigan slightly more at $9,125 a month. But if you go over to Arizona, it drops down to $7,908. Texas, we're at $6,540. So, you know, that's one of the factors we looked at. We actually just had this where we had a client, him and his wife, then in Michigan, and we were able to help him get Medicaid in Michigan to pay for her care. She needed 24-hour care, and he's moving to Texas, and he's bringing his wife with him, of course, and she's going to need care down there. And so that's one of those things where we had to make that connection to make sure that they'll still be able to get the benefits. But it's just, I thought this was a relevant and interesting look at Connecticut. Connecticut is $13,000, almost $14,000 a month. So, so something to think about, and something that's always part of our plan. A lot of people come in and they do a will with us, trust with us, powers of attorney with us, and they're just thinking about what happens after death. Of course, that's not the only question. The question is what happens during your lifetime? What happens, you know, what happens, what if you get sick? What if you have a stroke? What if you have Alzheimer's? What if you have Parkinson's? What, you know, and we're going to have a plan in place for that as part of your plan. I mentioned this earlier, but I'll just recap it here. Healthcare and end-of-life decisions. This is a very state-specific issue. It's messy. It's difficult. These are difficult questions, and every state kind of deals with it a little bit differently. Some states have just widely different laws as far as what you can do and what you're allowed to do and who can make decisions. And you know, Texas is very different than Florida, which is very different than Oregon, which is very different than Michigan. In Michigan, what we do is the recommended and preferred way to do it is you actually appoint somebody to convey your wishes for you. I actually kind of like that approach because, you know, you're sitting here at age 50 signing a document saying, well, this is what I'd want if I were ever in this situation, but you don't actually know what you'd want. I mean, I think most people don't have, you know, you've never experienced that. You've never experienced it. Maybe it's 20, 30, 40 years later. You're 60, 70, 80, 90 years old, and you signed this document so many years ago, and you think, and even if you just signed it 6 months ago, circumstances change. And so the idea would be to say, here's my general thoughts on this. This is generally what I want. If what most people say is they say something like, well, if I don't think there's any reasonable chance of recovery, or if I think the whatever the treatment's going to be worse than the cure, in other words, it's going to cause me all kinds of pain and suffering and not really give me any quality of life, then they would say I would allow my family to convey my wishes, which is to not continue treatment. And so that's probably the most common answer. But you know, some of the specifics about the details of, well, you know, would I want them to hold out for a week or a day or 10 days, or, you know, would I want to try this experimental treatment? You know, it's really hard to say until you have all of the relevant information. And so in Michigan, what you're doing is you're appointing the people that you trust and love and giving them some instructions. And then they have the discretion and authority to get a second opinion, to get a third opinion, to look at the options, to know you and know what you want, and to convey your wishes. So I think it's a good approach in Michigan. Now, does it have its drawbacks? Of course, it has its drawbacks. And that's why other states have had, for example, Florida, you can just sign a document. So you sign a document that says, I don't want any life support under these circumstances. I don't want any, you know, any, you know, medical treatment under these circumstances. And the thing is, that's very, you know, there's no discretion there. There's very little discretion there. You sign the document's enforceable. You're not saying, well, check with my spouse, check with my daughter, check with my son. So I kind of like the Michigan approach, but, you know, everybody has their own opinion on that. Real estate and property taxes is an important one. This is probably one of the things people are actually most interested when they're snowbirds, is to say, okay, well, what about, you know, in Michigan we have this thing called the personal residence exemption. Sometimes we call it homestead property, or, you know, capping of the property, so they can't reassess the property. Well, in Michigan, if you remember back years ago, they had that Headley Amendment where they put a maximum limit on what they can raise your property taxes on your personal residence, right? So sometimes families will come in, or a married couple will come in and they say, well, we got a house in Michigan, we got a house in Florida. Can my wife claim the house in Florida as her residence, and the husband claim the house in Michigan as the residence, and we'll get the personal residence exemption in both states, because Florida has something similar to Michigan? And the answer is legally no. I don't know if people are getting away with that or not. I don't know if that's just something that people are you know, doing. Legally, that's not, you know, that's not right. That's not the answer. Florida and Michigan both made that very clear. You got to pick. If you're a married couple, you can pick one residence between the two of you. Even if you're separated, you can pick one residence between the two of you that we're going to get the personal residence exemption, even if it's in different states. So that's just something interesting. And, you know, there's going to be a question about where's your residency and all of that. And so something to think about when you're making those decisions. And then this is kind of the final thought, and I mentioned this earlier, but I'll reinforce it. In the event that you have real estate in two different states, I'm going to recommend a trust almost every time. Why? Well, sometimes, you know, I tend to have a bias towards thinking that trusts are often going to be better, more thorough planning than just having a will-based plan. But I understand why lots of folks just want a will. And they have to understand the will is likely to go through probate, and we're going to have, you know, those issues of probate. But the issue of having property in two different states makes it even more important to really make sure that we have the trust. And not only that we have the trust, but that we've deeded the property to the trust. I can't tell you how many times that people have brought in their trust, and they had a Michigan house and they had a Florida house, and the lawyer drafted the trust and it was okay, and the lawyer drafted the deed for the Michigan property and it was okay. but the lawyer didn't draft the deed for the Florida property. And they just assumed the lawyer had, but they didn't. And the answer is, well, a couple things. They're not supposed to. The lawyer's not supposed to draft a Florida deed if they're not licensed in Florida. If they're licensed in Michigan, they're only supposed to draft Michigan deeds. And so could I draft a Florida deed? Of course I could. It's not that difficult for a lawyer that has some experience. But the Florida bar says that would be practicing law without a license, and I'm not supposed to. It's against the rules, and I follow the rules. So I'm not going to draft a Florida deed. But I look at it as our job to say, look, we're preparing a deed for or a trust for you in Michigan. I'm not just going to abandon you just because you have property in another state. So, for example, in Florida, I've got a friend. She used to work at a law firm that I used to work for. She was a lawyer in Michigan. Her and her husband moved to Florida, and she set up her practice down there. Now she's licensed in both Florida and Michigan, and so we typically have her. We got a few other attorneys down in Florida that we sometimes use, but typically we're going to make arrangements with the attorney in the other state to get that deed prepared for you and signed in our office. And we can do that in any state, any of the 50 states. If there's property, we're going to almost insist that we hire a lawyer in the other state, and it usually doesn't cost that much, and make sure that we have the house titled properly in the trust. Because if you don't, we could have done all this work. So all those, sometimes, I see this where we have somebody bring in a trust, and the lawyer prepared the trust, the other lawyer prepared the trust, prepared the deed for Michigan, didn't do anything about the Florida property. What's going to happen when you die? Well, we're going to go through probate in Florida, and we don't want to do that. And you say, well, I got a trust. Why would I go through probate? And the answer is because we didn't use the trust properly. We didn't prepare the deed that we needed to prepare. And so in our office, we never let that happen. We're always going to say, okay, you got property in another state. We're going to contact the lawyer in another state. It's going to cost you an extra $200-300 or something like that because it's a brand new lawyer, and we're going to make sure it's done right. And it's worth it, because why wouldn't we? Because otherwise you die, and now we're going through probate in California or Florida or Massachusetts and whatever else. It just doesn't make any sense. We wouldn't want to go through all of this effort to get everything right and leave out something significant like a real estate. So for those that have property in different states, I'm almost always going to recommend a trust because it just makes sense. It's going to save a ton of money, save a ton of aggravation, and not having to have two sets of lawyers in two different states, two sets of judges, two sets of probate courts, two sets of procedures, all of that just to settle your estate. So I wanted to see if anybody had any questions here. Savannah, I don't see any questions. I don't know if you did.
Nope, I do not see any questions.
So this is one of those things that I just want to encourage people. If you have a question, whether it's about going back and forth between two states or anything, random questions, we love questions for two reasons. Number one is we want to help folks. Secondly, it might be something that we'll do a webinar Wednesday on. So you send us your question, even if it's not relevant to this, send us an email, call in. Savannah's going to talk to you about how you can do a follow-up meeting with us and sort of interview us, especially if you're not a client of ours. We have a nice little procedure where you can interview us and decide whether you want to become a client of ours. And if you are a client of ours, then we can kind of screen your call and see who you need to talk to and all of that. So Savannah's going to talk you through that, what the next step is to make sure that if you have any follow-up with us, you have a great way to be able to do that. So thank you, Savannah. I'm going to have you go ahead and take over from here.
Thanks, Bob, and thanks to everyone who joined us today for the webinar. Now, as Bob mentioned, we do have a really easy way for you to get in touch with our team. I've actually put right into the chat box a link. It'll take you to Calendly, which is just a calendar. You'll open it up and choose a day and a time that you would like our team to give you a call. And as Bob mentioned, this call will last about 15 minutes. We like to call it an interview call because it gives you the chance to interview us. And then we can also ask important questions about your concerns and about the reasons that you're calling. Maybe we're the best firm to help you, but maybe we're not. So it's great to give us a call because we can at least direct you to someone who can help if we aren't the ones that can do that. So I encourage you to click that link and schedule the appointment. I've also sent you an email. Well, it'll probably be sending in about 10 or 15 minutes. You'll get an email in your inbox. So you can open that at any time and click that link. Now, if you don't want to click the link, if you just want to give us a call, you can do that too. I'll go ahead and type our phone number in the chat as well. And for those of you that are listening, It's 810-694-9000. Again, that's 810-694-9000. So if you don't want to schedule a time, you can just call us, and that's okay too, whatever works best for you. So again, thank you to everyone for joining us today. We will see you next week.